Major breaking news in the Matthew Hoover auto key card case. Crazy stuff is occurring with the Department of Justice. They've submitted this motion trying to stop the dissemination of information about this case, specifically involving what's known as the pre-sentencing report of Matthew Hoover's. I gotta tell you, this Department of Justice filing is, in my view, not up to snuff. We're gonna talk about it when I get right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Make sure you pick up a copy. It's doing really well, and I appreciate all of you who've reviewed it on Amazon. Thank you for that. I really do appreciate that. And don't forget to follow me on @4boxesdiner on Twitter, where I try to get out additional Second Amendment-related information in addition to this channel. All right, folks, we're going to get a little geeky here today about some procedural postures and some issues that you probably don't usually think about in the context of the Second Amendment. And that all involves the Matthew Hoover case. Now, just as a reminder for those of you who are not familiar, down in the United States District Court for the district, well, basically in Jacksonville, Florida, for the United States District Court there for Florida, in Jacksonville, Florida, there was a trial involving whether or not Justin Ervin and Matthew Hoover conspired and worked together to sell a machine gun. Basically, the argument by the Department of Justice was that this auto key card device, which was basically a piece of metal with etchings on it, whether or not that somehow constituted a machine gun under the federal statutory definition of machine gun, which is an item that can be readily converted, or something that can readily convert a semi-automatic firearm into an automatic firearm. And Mr. Hoover, Matthew Hoover, and Mr. Ervin were both convicted of this. As soon as they were convicted, the judge, I believe, put them both into prison for incarceration, subject and waiting for the sentencing. Now, the way these cases work, just to jog your memory in the criminal context, is you're criminally charged or indicted. There's a pretrial process. You're then tried. If you're found guilty, the next step is the sentencing process. Sometimes they put you in prison before the sentencing process. Sometimes they don't. They let you out. In this case, I believe both Mr. Hoover and Mr. Ervin were put in prison awaiting their sentence. The sentencing hearing is coming up. Before the sentencing hearing occurs, and what a sentencing hearing is the judge hears the discussions of the prosecutor about how much, what the penalty should be, whether there should be a prison sentence, if there is a prison sentence, how long it should be, and they hear from the defendants about any mitigating factors and things like this, and then the judge makes a decision. One of the things that occurs is there is a pre-sentencing report, a PSR prepared, which usually gets into information about the defendant's background, any issues, anything that might be relevant to the judge is prepared for the benefit of, among others, the judge, so the judge can try to get up to speed and make a decision as to what happens in terms of the sentencing of the defendant. So anything that's bad for the defendant or anything that's good for the defendant might be put in that pre-sentencing report. Now, the reason why this is all relevant, this background, is that what just happened is somewhat extraordinary in my view. Apparently what happened, according to the allegations submitted in a motion, which I'll put a link to down below in the description, the Department of Justice just filed what is known as a motion for order prohibiting the dissemination of the pre-sentence investigation report. This, again, was filed by the Department of Justice. The reason why this is important is because, according to this, Matthew Hoover got a copy of his draft pre-sentence report, which he's entitled to get, and he apparently gave it to a journalist, a famous, well-known journalist in the Second Amendment space. He's certainly famous in the Second Amendment space, John Crump of AmmoLand, among other things. And by the way, even this channel, the Four Boxes Diner, has relied on some of the reporting of John Crump in talking about the Matthew Hoover case back several months ago when the conviction came down, because I believe Mr. Crump went to every day of the trial, if not maybe every day or almost every day, and reported on it and did an excellent job by all counts. But nevertheless, apparently, according to this, Matthew Hoover provided a copy of the pre-sentence report about Matthew Hoover, by the way. Keep in mind, this was a document about Matthew Hoover, and this report was given by Matthew Hoover, allegedly, to John Crump and another journalist to basically talk about or do whatever they want with it. And in the context of that, John Crump reported on this pre-sentencing report and discussed it on his YouTube channel and perhaps in other contexts as well. So what the Department of Justice did is when they found out about this, they were apparently, listening in on Matthew Hoover's conversations from prison with Mr. Crump and others, and the Department of Justice filed a motion trying to stop the dissemination of this pre-sentence report, which I don't know what is in there, but that's what the Department of Justice doesn't want. But this Department of Justice argument, frankly, is rather silly. it's kind of meaningless. It doesn't make any of the points that I think have to be made for a whole host of reasons. But before I point out all the flaws in this Department of Justice submission, which I consider to be, shall we say, weak tea, let me just sort of bring you up to speed of some of the considerations here. As a general matter, as you know, under the United States Constitution, a government may not infringe upon our rights to free speech, and they may not infringe upon our right to freedom of the press. So here you have the government in the form of the Department of Justice and or the federal court potentially infringing upon both Matthew Hoover's right to free speech and his right to free press, as well as Mr. Crump's right to free speech and Mr. Crump's right to the free press. And obviously, Mr. Crump is clearly a journalist because he spent every day reporting on this and publishing it in Amalan, a respected Second Amendment related paper. And also, I think he was also talked about this others. And there's no debate. This Matthew Hoover case has drawn widespread attention, specifically that's been reported on. In fact, and this is killer for the Department of Justice position, is the Department of Justice actually issued press releases when they convicted Mr. Hoover. So any suggestion what the Department of Justice is trying to get at here, that, because their big argument here is not that there's anything confidential in the pre-sentencing report they don't want out, as best I can tell. They're really just upset that the public condemnation of the prosecution of this case, they're unhappy with that, and therefore they're trying to suppress this additional information. But that is not how the game gets played, especially with the fact that the Department of Justice undeniably, at least with respect to this argument, has unclean hands. And the reason why this doctrine of unclean hands is important in the law is because it's a defense to a request for what's known as equity. And that's exactly what the Department of Justice is asking here. They're asking for what's known as equitable relief. Equitable relief is something that the government forces you to do, which is distinguished from monetary relief, like I have to give you money because I stubbed your toe or I hurt your finger or something. I have to pay money. But then you have what are known as equitable remedies, such as like I have to turn over the house, I have to turn over the car, I have to mow your lawn, I have to do something that's equitable. But one of the defenses to equity is unclean hands. Now, the reason why I think there's a powerful unclean hands defense against the Department of Justice in terms of this request that's saying they don't want Matthew Hoover's pre-sentence report to be made public and disseminated and discussed publicly is that the government itself brought upon the notoriety of this case because the Department of Justice literally issued press releases on their website bragging about their conviction of Matthew Hoover and Justice Irwin. So if you're going to go out there and broadcast your successes in a public trial to the world, for the world to see on the United States government's Department of Justice website itself, you can't come crying to the judge and say, oh, well, there's too much notoriety and information and discussion about this case. Yeah, you brought it on yourself because you issued press releases about this case and bragged about your accomplishments. You can't have it both ways, and therefore I think there's a powerful unclean hands defense against the Department of Justice here. And again, if the Department of Justice is so concerned about this case, why are they publicizing it with press releases? Inquiring minds want to know. But let's go beyond that. Aside, of course, from the fact there's First Amendment concerns here, don't forget that this case touches fingers with the Second Amendment. That's another reason why the public's very interested in this case. Not only are they interested in this case because of First Amendment considerations, because as you remember, the issue is this key card arguably was a document with writing on it or a piece of art because it was an etching that had, parts etched into it that in theory could be knocked out and you could make it in theory convert a semi-automatic firearm into an automatic firearm. I'm highly skeptical anybody could do it. I certainly would like to see a ATF agent take one of these auto key cards and from start to finish, from getting the auto key card all the way up to making it fire fully auto. I'd like to see that process to see if that's real. I'm betting you dollars to donuts that probably could not happen, at least with most people. So any notion this is readily convertible or this piece of etching, this auto key card could make a semi-automatic firearm readily convertible into a fully automatic firearm. I'd like to see someone try that with the ATF to see if they could actually pull it off. And I want to see that film start to finish, womb to tomb, meaning from the acquisition of the card all the way to the insertion into the semi-automatic firearm and then the use of the semi-automatic firearm as a fully automatic firearm. If I don't see that videotape womb to tomb the whole way with the videotape literally on that piece of metal, then I'm not trusting that this can readily convert a semi-automatic firearm firearm into an automatic firearm if I don't see it with my own two eyes. Nevertheless, let's continue on here. The other reasons why this Department of Justice submission, in my view, should not have been made. If I were the lawyer in this case for the Department of Justice, I would not have filed this because I'd be like, this is not going to go. I think I'm going to get my butt kicked, and it's not very strong. So I would probably not have done this. Now let's continue on. There are instances, by the way, of where pre-sentencing reports can be kept confidential, but the report itself is generally not kept confidential. Parts of the report can be kept confidential. Specifically, parts of the report can be what's known as redacted, which means you cross it off and you see a bunch of the report, but parts of it can be redacted. When does this arise? Well, from the Department of Justice's point of view, there's really only a couple instances where this could pop up, potentially, and there's no suggestion whatsoever that what I'm about to say in terms of exceptions to the public rule is found in this Hoover case. Specifically, if, for example, in the context of the pre-sentencing report, the government interviewed, let's say, a confidential informant. You have someone inside the gang talking about what someone did in a criminal gang, and you don't want that confidential informant's name to be made public because then he will be killed by the gang. Well, that's an example where you might use information that you glean from the confidential informant, but you have a legitimate, compelling state interest not to reveal the name of the source because he may get killed or he may get found out, and now you no longer have the source within the criminal gang. That's an example where you would use the information, but you might redact that part of the pre-sentencing report for obvious reasons. Likewise, if you're dealing with someone who's a violent criminal who has a long history of beating people up and committing murder and doing bad things to them, if you interview victims, prior victims of the criminal defendant that don't want their name revealed because they fear retaliation and getting murdered or beat up or whatnot, you might in that instance allow the information to come in, but keep the name of those victims interviewed about the criminal defendant to be kept confidential because you're dealing with a potential violent threat, an actual violent threat to someone who's a known violent thug. In this case, I'm not aware of anything involving violence associated with this case or Matthew Hoover or Justin Irvin or anything like that. This is involving a technical violation, arguably, of the National Firearms Act, where you deal with something that can readily convert a firearm into a full machine gun. That would be what I consider in Latin, and we've talked about this on this channel before. Specifically, this is what's known as a malum prohibitum crime. Malum prohibitum, which just means something that's not evil in itself. That is to be distinguished from what's known as a malum in se crime. Malum in se crimes are murder, rape, robbery, fraud. You know in your heart of heart that what you're doing is evil and wrong. You don't need the law to tell you. Malum prohibitum crimes include like jaywalking, anything that sort of the government just makes up, the length of a barrel of a firearm would be another example of a malum prohibitum crime. And again, here's another example, a piece of device, whether or not that readily converts a gun into a into an automatic firearm. There's nothing evil about that process. It's a crime simply because the legislature says it is. There's nothing immoral or inherently evil about that process. It's just a crime because that's what the government says so. And that's what makes it what's known as a malum prohibitum crime, as distinguished from things like murder, which are known as malum in se crimes, evil in and of themselves. Again, there's nothing in this Matthew Hoover case that speaks to malum in se, so I don't know what possible information in this pre-sentencing report that the government would not want, because there's no suggestion that Matthew Hoover is going to do anything violent. And by the way, there's no suggestion that anything is here. The other thing, of course, is you might see something about sources and methods of how they uncovered information. Nothing, again, is mentioned in this report. The only thing that really this government agent, this Department of Justice attorney is talking about is she's very upset on page number 4 of her brief. She lists a bunch of comments on the website, specifically on the YouTube channel. Now, keep in mind, these are not comments made by John Crump. They're not comments made by Matthew Hoover or anyone associated with the case. These are just comments that people make on YouTube channels. We don't know who these comments are from. We don't know if any of these comments are people that work for the government. We don't know if any of these comments are people that come from the United States. We don't know if any of these comments are from bots. We have no idea who these comments are from. The ones that are unhappy with the government, the Department of Justice, and so on. But here's the critical thing. Again, if the government did not want to bring attention to this case, why are they issuing press releases? Why do they get to issue press releases and talk about this case and boast about this case, and then they're upset when someone writes about this case? You can't have it both ways. Let's go beyond that. Even Even with that said, the problem, and here's a causation problem, and this is critically important. This is a little geeky, but it's important to understand. It's causation. Now, but for causation, the government simply is not going to be able to prove on this motion to keep this Matthew Hoover pre-sentencing report confidential. They're not going to be able to prove causation. And what does that mean, Mark? What that means is they're not going to be able to show that the pre-sentencing report is the cause of people being mad at the United States government and the Department of Justice in this case. Because the people are upset with the United States government and the Department of Justice in this case because they're unhappy with the prosecution itself. They're unhappy that these people are being put in prison for this malum prohibitum crime associated with an etching card that violates the National Firearms Act where there's no actual victims. That's the key with all these things. There's no actual victims. This is, again, a malum prohibitum crime, an administrative type crime with no actual victims. And that's why people are upset about this prosecution. It has nothing to do specifically with the pre-sentencing report. It has to do with the case itself. And whether you allow the pre-sentencing report to become public or not, it doesn't matter because the people are still going to be upset with the existence of the case itself. Now let's carry on. Now the other interesting thing here is, of course, there's an old famous metaphor in the law, which I actually used in many trials in my day. It's called you can't unring a bell. I'm not going to talk about some of the things I might do to try a case in front of a jury. That's for a separate video, but we must do what we have to do to win. Nevertheless, the notion of unring, you cannot unring a bell is, of course, once someone hears something, they can't unhear it. So it seems to me, if the Department of Justice is right, is this pre-sentencing report has already been given out to John Crump and to others, and it's already been made public, then what's the point of your motion? Because it seems like you can't unring the bell. You're not going to be able to get the document back. Presumably, it's already been publicly disseminated and talked about. So what are you doing here? You can't unring the bell, as they say. You can't put the horse back in the barn. Now, what has John Crump done here? And we're going to talk about some strategy discussions just briefly here. He's represented by several excellent lawyers, including Steve Strambule out of Mississippi. You've heard a lot about his work in the Second Amendment. He does excellent work. Of course, he's representing John Crump with some other lawyers. They have filed an emergency motion to intervene for the limited purpose of responding to the United States motion for this order. Now, that means John Crump is, as a journalist, has moved to intervene in this case. Now, there's an interesting strategy question here. I have a big picture question as to whether or not you needed to move to intervene here if you're representing the journalist. The reason why I bring this up is if you think about it, right now in this case pending in the Federal District Court in Jacksonville, in the Middle District of Florida, right now it seems to me the court has jurisdiction over the defendants of Mr. Irvin and Mr. Hoover, but I'm not quite sure how the court has jurisdiction over the journalist John Crump, because John Crump is not a party to the case. It seems to me the only way, I can come up with some arguments going both ways here, but one possibility is that whatever the court says, right now at least, would only be binding upon Matthew Hoover and Justin Irvin and the Department of Justice because they're the parties in the case. I'm not aware of any other party in this case. So even if a court enters an order that's binding on the parties, it's not crystal clear to me that the court has jurisdiction to bind non-parties to the case, including Mr. Crump. Again, I'm not familiar with all the details. There can be arguments all sorts of ways the Department of Justice could make, so I'm not giving legal advice here. But it just makes me wonder whether or not Mr. Crump has to even file a motion to intervene and get involved at this point, because if Mr. Hoover wins the argument, says I'm allowed to give it my stuff. I mean, after all, it's a pre-sentencing report by the probation office about Mr. Hoover, so why can't Mr. Hoover give out his stuff about Mr. Hoover? I mean, it seems like he has the right to waive any confidentiality if it's all about him. Again, those narrow exceptions I mentioned involving confidential informants, but there's no reference to anything like that in this motion for the Department of Justice. Of course, I haven't seen the document, so I don't know what's in there. But with that said, John Crump's filed this motion to intervene. He wants to defend his First Amendment rights, and I think there's a very good chance that he's going to prevail, because I think the first question out of the judge's mouth is going to go to the Department of Justice and be like, what exactly is it that you don't want made public, counsel? What's bothering you exactly? And if the only thing out of the lawyer's mouth is, I don't want to be attacked in the press more, and the judge is going to be like, well, you brought the case, you issue press releases about the case, it's a high-profile case, people are writing about it, what does it matter if the pre-sentencing report gets out or not? right? The case isn't going away. It's going to go to an appeal. We're going to have a sentencing hearing. So what do you care, Department of Justice? What's in this report that you don't want out there? And if there's something specific, Department of Justice, you don't want out there, tell me now, is what I think the judge might say, because maybe we can just redact it and resolve this problem without any more headaches, because the judge is likely going to say that obviously there's First Amendment concerns here for the freedom of the press. There's First Amendment concerns associated with the freedom of speech. There's also, of course, don't forget, the public has an interest here because, and I've said this repeatedly on Fox News about things like the Hunter Biden case and the Department of Justice is handling that. The way courts function, it's not just enough for a process to be fair. Yes, it has to be fair, but there's another thing that courts also strive to do, and that is to make sure that the appearance of fairness is satisfied, because that's equally important as well. And certainly I could see the judge being like, well, if this information is out there, people are interested in the case, the more they know about it, the more they're going to perceive the right and the wrong of it and can be able to publicly comment on it, whether it be members of the press or just members of the public. So I think there's a very good chance the court's going to be, no, Department of Justice, get out of my courtroom. I'm denying this motion. This has all sorts of constitutional implications, and you haven't given me a single compelling reason other than you don't like to be criticized, but that's about the case and not about the pre-sentencing report. I don't see a single reason why I should grant this motion. Nevertheless, we will see what happens. And again, I'm not even sure that the John Crump motion to intervene needs to be granted to resolve this in his favor. But again, I guess it will give him an opportunity and his lawyer an opportunity to argue in front of the court to make sure all the arguments are being made properly. And I do think in some ways Matthew Hoover's interests might diverge or be different from John Crump's, because obviously John Crump is not going to prison and Matthew Hoover is in prison. So I could see why their arguments could be slightly different from each other. So I could see why John Crump, the journalist, would want to make particular arguments that are unique to him and separate and apart from those that might be made by Matthew Hoover. Nevertheless, I'll keep you apprised. I'm sure a lot of other channels are talking about this, but I thought this was important enough because this involves some high-level constitutional work, and I thought the Department of Justice brief was pretty weak tea here, and I suspect it's not going to go that well for them. But again, I haven't seen all the documents. I haven't seen the pre-sentencing report, so maybe there's some magic gem in there that I'm missing on this video, but we'll know more tomorrow because the hearing is apparently tomorrow, and we'll see what happens there. And good luck to Matthew Hoover and Justin Ervin in their ongoing fight down there against the Department of Justice. It seems to me this was a prosecution that looked a little bit overreaching from my point of view. And, again, I'm not sure I would have brought it if I were the Department of Justice, but I'm not. So we carry on. Okay, folks, thank you for watching this video. If you haven't subscribed to the 4 Boxes Diner, please do so, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.